So the basic language of Article 51, this is not news to you, but just let me review it for our purposes. Article 51 says, nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member state. So nothing in this charter should interfere, impinge upon the inherent right of self-defense or collective self-defense, individual or collective self-defense, if an armed attack occurs. Now, the first point that I'm going to address is what we learn by looking at other translations of the Charter. And the second point that I'm going to address is what we learn by comparing the international law of self-defense with something I know much more about, which is the individual law of self-defense. It seems to me obvious that international law of self-defense takes the states, the member states of the international community, as individuals acting as individuals in situations of armed conflict, and that there is a strong analogy between individuals defending themselves against muggers on the street and states defending themselves against armed attacks. So now the question is, can I make that analogy work, and what are its limitations? But first, I'm going to talk about the problem of translation. Now, what I discovered in looking at the definition at the Charter in French and Spanish is, first of all, it doesn't say inherent right. It says droit naturel. It says natural right. A natural right, de légitime défense. You have a natural right of légitime défense. It doesn't say self-defense. It says you have a natural right of legitimate defense. Well, it was obvious to me as a criminal lawyer why they said that. Interestingly enough, the Russian translation says samoobrona, self-defense. This is totally bad Russian, but they did that copying the English version. But the French and the Spanish, which are official versions of the UN Charter, mind you, rely upon this term legitimate defense. It's not about the self. It's not about protecting the self. It's about whether the use of force is legitimate. Now, it was clear to me why they did this. Why did they do this? Well, if you read a book on French criminal law, or on German criminal law, or on Spanish criminal law, and you look for the subject called self-defense, you won't find it. What you will find is a chapter that's much broader called Notwehr in German, necessary defense, or légitime défense in French, legitimate defense. So they were good translators, using the correct language from the domestic criminal law to refer to this right, this natural right that all states have if an armed attack occurs. What's the difference? There are enormous differences. And in the international sphere, the differences are earth-shaking. We have a special law under the Model Penal Code and under domestic criminal law called defense of others. So that in the history of the common law, there was a slight problem whether I could go to the defense of someone who was being attacked on the street. Originally, the common law said you can only go to the defense of members of your family or your employees or people who stood in a particular relationship to you. As of the 16th century, the common law said, we are generalizing. We are generalizing this right to defend other people, and you can defend other people under the same conditions under which you can defend yourself. This was a very important intellectual breakthrough because it was a recognition that self-defense was a matter of right, and it wasn't simply an excuse based upon the pressures of the circumstance. When we had these relationships built into the law, the basic idea was, well, you see your child being attacked, so you have to go to the aid of your child. You see your husband being attacked, so you have to go to the aid of your husband. These are natural desires. We cannot blame people for acting on their natural desires. But what if the person is a stranger and is being attacked on the street? Do I have a right to go to that person's aid? Eventually, the law developed so that the clear distinction between doing something as a matter of excuse and doing something as a matter of right became intuitively obvious to the criminal lawyers. And they said when it was a matter of right, well, also there was a big practical consequence to this, because if it was merely excusable homicide, you still had to forfeit your property. But if it was justifiable homicide, you didn't forfeit anything. So this was of great significance in the development of the law. To say this is the right thing to do, you are to be acquitted. It's not simply a finding of excusable homicide which will leave consequences. You are to be acquitted because you have done the right thing. In the law of self-defense as is developed in the common law, the defense of others has become equivalent to the defense of self.